our next session. And really, normally we would kind of bring international keynote speakers into QUT to talk about topics when we hold a big conference. Because of all the COVID travel restrictions, this time round we've tried to bring in some international perspectives through some recorded videos. We have a presentation by Professor Lucas Osborn from the Campbell University Norman Wiggins School of Law on 3D printing and intellectual property, looking at his latest book.
Thank you so much to the QUT faculty and institution and to Professor Rimmer for inviting me to speak about 3D printing and intellectual property. It's an honor to be able to talk to you from a long distance away. One of the silver linings of COVID is we've embraced the technological ability to reach different audiences much more cost effectively. So I'm very thankful for the opportunity. It's the first time to speak to an Australian audience. And it's an honor to talk about the topics covered in my book, which was unoriginally titled 3D Printing and Intellectual Property, but at least you know what the book is about. And I do tend to use the phrase 3D printing as opposed to additive manufacturing, simply because that phrase has captured the attention of lay people across the world. And it's such a dynamic and exciting area, both 3D printing and the maker movement more generally. And it's fun to be a part of and to analyze the changes and the legal pressures that are being put on our system. This was very powerfully captured in the news and in my own experience with the COVID, PPE, personal protective equipment shortage, both in the United States and worldwide, where we were trying to figure out how to protect our healthcare workers, manufacture masks and holders for masks and other equipment, even ventilators that makers were looking how to make a ventilator quickly and cheaply. And I was fielding numerous phone calls and inquiries on the legal side. What can we do? What can't we do? Many of us followed potential accusations of infringement and followed the backlash against that. And so that's just a single example of how maker movement and 3D printing technology is allowing shifts in the dynamics of who does the design, who does the manufacturing, who does the potential infringing. And those are difficult questions that we need to address as we move forward and as 3D printing technology progresses. Now, 3D printing is developing along three axes, at least three axes. And that's important, I think, for policymakers to understand, because you have developments on the hardware side. So the hardware would be the 3D printers themselves or the 3D scanners themselves. And what can these 3D printers do? How fast can they do it? With what tolerances can they perform? With what cost can they do it for individual 3D printers, right? And these things will be developing at some, fits and starts. And then you have the software side, the software to run the 3D printers, the software to run the design programs as I design something in a digital environment, the software to take 3D scans and translate them into usable files, the software to take CAD files and translate those into 3D printable files. And that software is going to continue to develop and improve. And then finally, another axis that's important is the materials that one can 3D print in. Although there's a vast array of materials that people can use, there's more materials coming online every day. And compared to traditional manufacturing techniques, the amount of materials that are available is relatively small. So the more that these three axes develop, the more that 3D printing will start to invade different industries. And then it's disruptive, right? We hear a lot about how 3D printing is disruptive, and you actually have some swings in the popular press where 3D printing is hyped up to be this ultimate disruptive force that's going to change everything. And then it doesn't change everything. And then you hear, oh, it was overhyped. There's really nothing to see here. And the truth is somewhere very much in the middle, right? And I think of disruption for 3D printing as both fast and slow. And I think that's important for policymakers to realize, right? Is that on the one hand, the disruption is slow because it's not like the internet. It's not like an internet company that's instantly scalable to billions of users overnight. That's just not the kind of technology. We're developing the hardware, the software, the materials, and there's going to be fits and starts there. So in that sense, it's relatively slow. But in another sense, it's slow like an amoeba that has its pseudopods reaching out into different areas of manufacturing. And when a particular area of manufacturing, when a particular product hits a point where 3D printing, additive manufacturing, is a viable manufacturing process for end product uses, for final manufacturing, for that particular product in that industry, it's incredibly fast. Things change overnight. All of a sudden, everything that I'm going to talk about and that you're going to hear about in this conference becomes instantly relevant. Not, oh, it's slow, it's not taking over the world, but for that product in that time, everything is instantly relevant. And that's important to see that even though we can't 3D print an iPhone today, that doesn't mean 3D printing is not disrupting technologies and that it's not putting pressure on intellectual property regimes, among other things that you're going to hear about today. So I want to focus on some legal aspects of 3D printing technology and what pressure it puts. And a key concept that I talk about in the book is a term I coined called physitization, right? And physitization is the portmanteau of physical and digitization, right? And what the physitization phenomenon is the bidirectional pathway that now exists between tangible objects on the one hand and digital versions of those objects on the other. And that bidirectional pathway that I can start with a physical object, I can reverse engineer that through 3D scanning or looking at the object and recreating it in a CAD environment, and I can go to the digital. Or I can start in the digital and go to the physical. I can go back and forth. And that is a key concept to understand how 3D printing technology puts pressure on intellectual property law in the ways that have not happened before. So it's helpful to compare physitization with a little bit of history for intellectual property law. IP law, like most law, was largely built on the fundamental assumption, background assumption, of the physical and the tangible. So most of patent law is dealing with physical devices, physical machines. You do have methods and processes, and those are in a sense intangible, but those methods and processes were utilized with tangible objects. And so there's a lot of assumption there that starts with, oh, well, everything is physical. And then we did already have a digitization phenomenon in the law, starting with computerization and really hitting the ground in the 60s, 70s, and 80s with software, and then eventually digitization of music and movies. And that put a lot of pressure. We all heard about Napster and Grokster and those sorts of things. And we heard about how the music industry was tremendously disrupted and maybe it would fail, and it didn't fail. But that was digitization. And in that sense, you were going from something that was tangible. I used to have a compact disc. I used to have a tape that had music on it. But I digitized that. But you weren't really going back and forth between the digital and the physical. Once it was digitized, it just stayed digital. And that made the most sense, by and large. Right? And that phenomenon of digitization really, for the most part, disrupted copyright law more so than patent law, trademark law, design law. And that's a difference, I think, between digitization and physitization. Are there analogies? Yes. Can we learn stuff? Yes. But physitization is different than digitization, and therefore it's going to put pressure on the law in different places. And so I want to just introduce a few areas that I do talk about in the book that I think are novel ways in which this physitization phenomenon puts pressure on our intellectual property regime. Now, there's plenty of ways in which 3D printing is going to interact with intellectual property law in ways that are not new. But I'd rather spend my time focusing on some of the ways that it's going to interact in new ways that we haven't seen exactly before. So I want to start with patent law. And patent law, let's start in an era before physitization, and somebody invents a machine, a widget, a thing. What would they do when they invented that? Well, they would go get a patent, and they would draft the patent claims to cover that tangible object. Now, patent claims are something familiar to patent lawyers. That's the end part of the patent. And it is a very important part of the patent that specifically describes, here is the invention that I claim the right to stop other people from using. And so you can write whatever you want in the bulk body of your patent, but it's only that stuff at the end that really defines what's your patent that you can stop other people with. And so when you weren't thinking about 3D printing in that era, you would draft a claim to your physical widget, and that was it. But even now, with all these patents still in force covering physical widgets, 3D printing is going to put pressure on some of those patents. To the extent those patented items can be 3D printed and 3D printed in a usable way, we have problems that we haven't seen before. Why? Well, let's start with the concept where I'm an individual and I have a 3D printer in my house, and I 3D print an object that is covered by a patent. When I 3D print that object, I have made that object, and that is an act of infringement if that object is covered by a patent, right? So as soon as I make, use, or sell the invention, the tangible version, I'm an infringer. I don't have to know about the patent. I don't have to intend to infringe. I don't have to know I'm doing anything wrong. It's what we call strict liability. And this has been true for hundreds of years, but it didn't really matter because not that many people in their homes had manufacturing capability to infringe patents. But now we do. So these poor individuals in the United States, and as I understand it still currently in Australia, you make it, you infringe, whether you know about the patent or not. There's no exception. Now, many countries have what we call a private non-commercial use exception. So if I make it privately, it doesn't mean secretly, but it means in my home, and I'm using it for non-commercial reasons, I'm not out there selling it, then it's not an act of infringement. And that's very helpful in an era of 3D printing, right? This takes a lot of pressure off those poor individuals who don't know they're infringing patents, and that's a nice thing for the individual. In the countries where there's no exception, there's a lot more pressure on the individual, right? And so we'd say, oh, poor individual. But we also have to recognize that in an era of mature 3D printing, individual 3D printing, you also need to feel somewhat sorry for the patent holder, because a private non-commercial use exception pre-3D printing didn't really affect the patent's value at all. But if all of a sudden I have products that are patented, that individuals can print in their homes, my patent has become vastly less valuable. Number one, in countries where there's no exception and there's technical infringement going on, how do I know? How do I, as a patentee, detect that infringement? That's going to be difficult and costly for me. Therefore, my patent's less valuable. On the other hand, if I'm in a country with a private non-commercial use exception, all of a sudden 3 million people are printing my invention and not paying me anything for it, and the value of my patent has decreased dramatically. And so we've got a tension here. On the one hand, it seems very unfair to burden individuals, innocent individuals, with significant liability and legal fees. On the other hand, we also could feel sorry for the patent holder who has lost tremendous amounts of value for their patent if their patent is for a product that can be manufactured with 3D printing. And how to balance that is not entirely clear. And I think even in countries with private non-commercial use exceptions, you're going to see tremendous pressure to say, hold on, wait a minute. When 3 million people are printing their objects in their house instead of paying the patent holder, I'm not sure we want to call that an exception. Maybe we'll say that's not really non-commercial use. We can get creative and say, instead of paying, they're making, and the alternative of not paying is a commercial choice, and so that is actually a commercial use. It's not maybe what the law was intended, but maybe the law will adapt that way. So we need to think through that for the individual, and we need to think through that for the patent holder. There's a third party, and this is very important to the maker movement out there, and these are these intermediary places that will have more sophisticated printers, and they will print objects on behalf of individuals, right? So I can't afford the $1 million printer for my house, but I can go to what I call a print shop, a 3D print shop, and I can take my file or I can upload it on the web, and they'll print it, and they'll mail it to me, or I come and pick it up. Understand, these 3D print shops, and Makerspaces sometimes fit the bill there. It's a place where people can come and they use a community-based 3D printer. Well, if that print shop or that makerspace is the one in control, then they're the ones that are doing the printing. That means they're the one making the object. That means they're the one infringing the patent. They don't know they're infringing. They wouldn't seem to qualify for a private non-commercial use exception. And so now we put tremendous pressure, financial risk, legal risk on 3D print shops. And that's something the law is going to have to think carefully about. Because 3D print shops and makerspaces, they have tremendous social utility. Now, if they start being co-opted in some places to repeatedly and knowingly infringe patents, we probably don't want that, and there's going to be a lot of backlash against that. On the other hand, if they are places of goodwill and trying to do the right thing, there's a tremendous problem in patent law that wasn't there really in copyright law. So in copyright law, you have the traditional two-dimensional print shop, right, that's got copiers. And we had an era where there was big problems where copy shops were making copies of copyrighted material. And we have various laws that say, stop, you don't do that, and you have to police it, and you can't knowingly do that. And that analogy doesn't port into the patent world very well at all. And so we need to be aware of that, because it's relatively easy to know if something that you're making a paper copy of is covered by a copyright or not. Usually they have a copyright symbol, and we just know that most books out there are covered by copyright. That's just the nature of copyright law. You can't say that with physical objects. You can't look at an object and say, oh, that's patented, that's not. I can't look at a digital file and know, oh, yeah, that's covered by a patent or not. Right? Even if I hand you a patent and I ask you as a layperson to read it, you're not going to have much of a chance at all figuring out whether that patent covers a particular CAD file or 3D printable file or physical object or not. And that's not insulting anybody's intelligence. That instead is just pointing to the realities, the intricacies and arcaneness in some way of patent law and patent drafting and those claims and claim language. It's a very specialized legal field. So there's a lot of pressure on 3D print shops who will face potentially very big liability, or even if not tremendous liability, tremendous legal cost for innocently printing something that is patented. And so the law is going to have to take this into account and balance these things in an appropriate way as 3D printing technology matures. And again, we can't wait until there's a 3D printer in every home, because for certain industries, these things are currently 3D printable in an end user kind of way. And for them, this is the reality already. So we need to think about that. There's no easy way to figure out what's patented and what's not. That's just for that topic right there is just for traditional patents. Traditional patents drafted toward the tangible object. But of course, what the patent holder is going to want to do in a 3D printing world is have a claim to the tangible object and another claim to the digital version of that object. And I simply just don't have time to talk about the problems and the difficulties the law faces with that. Suffice to say, patent holders are going to have a lot of difficulty getting valuable patent claims to digital versions, where I can stop you from posting digital files of my patented object. I might be able to capture you through indirect infringement, and Professor Abbas, as I understand, is going to talk about indirect infringement, but there's some hurdles with indirect infringement you're going to see. So for direct infringement, that strict liability, it's going to be very difficult to get those kind of digital claims, and we need to think about how to do that. So that's just patent law. We have trademark law to think about as well, and one of, I think, the most interesting things when we think about trademark law is, and this somewhat parallels debates in trademark law generally, is what do we want trademark law to do, and what do we want it to protect and protect against? One of the main traditional things trademark law did, a trademark served as an indicator of source. And when we said indicator of source, we typically meant manufacturing source. So that if you manufacture good shoes and you put your logo on the shoes, that logo, that trademark becomes a repository to indicate this came from that company that does a good job of manufacturing. Well, when 3D printing becomes widespread for products, the manufacturer is no longer this foreign company, this hidden entity. The end user is the manufacturer. Manufacturing has been democratized. And so that source indication of trademarks is gone. I'm the source of the manufacturing now. You're the source of the manufacturing. And so we need to think hard about what we need trademark law to do in an era where I am the manufacturer, and in many ways I can be the designer, either the original designer, or I can personalize the design that's already out there, co-opt it and change it and adapt it for my uses. So I become the designer and the manufacturer. And then we need to think hard, what do we need trademark law to do? And we don't want to assume that trademarks need to necessarily be stronger. We don't need to assume that they just need to go away. We need to have some good conversations about what it needs to do and what it doesn't need to do, keeping in mind various incentives that we want to create. Copyright law. Much of copyright law is actually well positioned to deal with 3D printing because it's already faced the digitization phenomenon. But one area that I think copyright needs to pay careful attention is the area in which copyright law overlaps with patent law. Patent law traditionally deals with the utilitarian objects, whereas copyright law traditionally deals with creative, artistic, aesthetic type creations. And what we don't want to do is to use the copyright regime with its quirks in design to protect utilitarian objects. We don't want that, the backdoor copyright. How could this happen? Well, if I have a shovel, that's just a basic shovel, that is a utilitarian object. It is not eligible for copyright because it's, at least in many legal systems, because it's purely utilitarian. However, if I paint a picture of a shovel, that painting is covered by copyright, but that painting being covered by copyright doesn't affect the utilitarian buying and selling of shovels. It just sort of stands by itself. If we're not careful, we're going to assume that CAD files and surface mesh files, design files, 3D printable files, are like that painting, and that therefore they should be protected by copyright per se. But we need to be careful because the physicization phenomenon has taken what used to be blueprints that were relatively inert, and they've moved them way down the spectrum toward much closer to the tangible object, much closer to the utilitarian object, which if it's going to be protected would be protected by patent law. And so we may not want to protect this digital file with a copyright because that's now going to have copyright messing with, if you will, the incentive structure that patent law was there to create. And it might decrease access to utilitarian objects. And that may not be something we want as society. Finally, I also talk about design rights. And there are some big questions in the design world. And the EU and much of the rest of the world, frankly, does a better job than the United States system protecting design rights and creating exceptions for things like speech, certain commercial activity, and those sorts of things, whereas the U.S. law just doesn't mention it. Now, there's ways that our common law system can import those protections outside of a statute, but it's not clear how and when that will be done. On the other hand, the EU and some of the stronger design regimes need to be careful, kind of in the same analogous way that we talked about with copyright, because designs are thought of as visual things, utilitarian objects that are somehow creatively made and have some beauty attached to them that is separable from their, in some way is conceptual, I should say, separate from their utilitarian characteristics. But we don't want to protect any drawing on a computer screen with design rights, because you might then use design rights to protect that 3D printable file of a purely utilitarian object. And if that utilitarian object itself would not qualify for design protection, we don't want the drawing of it to necessarily be protected by design rights. So lots of balancing to do in each area or sphere of intellectual property law. And it's going to take a lot of work and a lot of careful study. And it's not a simple task. So in conclusion, where do we want to go? My proposal is somewhat broad. I offer some more specific things in certain areas. But overall, I want to be careful for utilitarian objects. We need to keep innovation policy writ large front and center. We need to recognize that there are pressures on the intellectual property regime brought by 3D printing. In some ways, they weaken patents. In some ways, they make individuals more vulnerable. But there are also changing costs of innovation. 3D printing technology dramatically, in some cases, lowers the cost of design, prototyping, and in manufacturing in a way that says we should look closely at what intellectual property law and patent law specifically needs to do. How much incentive does it need to create? And for even outside of utilitarian objects, we need to realize that there are fundamental shifts in the control of design and manufacturing as 3D printing matures, and we need to do careful analysis and balancing so that we don't marginalize certain groups who are newly empowered, and yet the law closes them off. We don't necessarily want to throw everything away, but we need to look carefully at how can we create a legal structure that allows 3D printing to bring the most good to society. And that's going to take a lot of hard work, and there's not a ton of easy answers. So I really appreciate the time that I got to speak with you. I really look forward to the rest of this conference, and I hope that you do too. Thank you very much.